Morning, Ms. Miranda.
SJC-10568, Commonwealth, Miranda.
Good morning, Mr. Shaw.
Good morning, Chief Justice Marshall, and may it please the Court. If the Court would allow me, I'd like to begin this morning by reviewing very quickly the foundational facts in the evidentiary record giving rise to the issue of cash for testimony. And then I'd like to suggest to the Court a framework that the Court can utilize to look at this issue and resolve the issue consistent with cases, constitutional principles, and 268A, Section 3, the anti-gratuity statute. What we have in this case, made clear from testimony during trial, which really hasn't been disputed and I don't think can, is we have the state by and through the prosecuting attorney who participated in what really was a coordinated system. And if you look at Mr. Mathis's testimony,
the jury knew all about the payments that had been made to these people. Is that correct?
that's correct.
Okay, so there was no problem about non-disclosure or not getting it before the jury.
The initial disclosure, Justice Cowan, was the letter that the prosecutor sent. It was the defense who then found out about the reward program and compelled further disclosure about the program. But yes, the fact is that at the time of trial, there was disclosure.
I know you asked us to wait and let you lay out everything, but I've got to ask you, how is this situation different than the reward programs all over the country? You see it on television where they talk about, there'll be a reward for the arrest and conviction of a person.
Well, that goes right to the point. So let me jump to the analysis that I think the Court needs to apply. I think the Court needs to look at these issues on a spectrum. And on one side of the spectrum, you have the prosecutor paying its own cash to its own witnesses. Okay? On the other side of the spectrum, you have a completely private entity paying cash for some sort of participation in a case related to allegations. And the question,
how can we stop them, or how could the DA stop them?
well, but again, if you look at these cases on a spectrum, I think you have to look at certain factors. Certain factors are going to determine whether there is a violation of the defendant's right. And the first is if the reward or the cash is going to a testifying witness.
What is the defendant's right? Using the phrase you just used, what is his right that you're focusing on?
Well, it's his right to fundamental fairness. It's his right to due process of law.
But didn't he get fundamental fairness by exposing all this dirty laundry in front of the jury? Isn't that the fundamental right?
No, I don't think so, Your Honor.
So he has a fundamental right not to have a witness paid for testimony.
He has a fundamental right to be tried by a process, the mechanism by which he is convicted and imprisoned for life. He has a right to be prosecuted through a process where the prosecuting authority is not engaging in something that facilitates cash incentives contingent on outcome.
If Chapter 268A did not exist, could you make this same argument?
I certainly believe that we could.
But how can you make the argument, given that we have already accepted the fact that there can be all sorts of plea bargains, immunity, that somebody who's guilty of murder can, being an accomplice in some way, can walk off scot-free, so that we can buy off years in prison, but we can't pay a few $1,000s?
That's what's ingrained in our system, Your Honor. But I think, again, if you look at these three factors that I'm going to suggest to you, you will see that these are outside of anything that has been part of the norm in our system or anywhere in the country.
Wouldn't you say that your life in prison is a lot more valuable than, a couple of years in prison is more valuable than $2,000 or $3,000?
Well, but we don't allow those circumstances to exist where a plea bargain is contingent upon a conviction. And this court,
is it the contingency that
well, there are three factors. Number one, it's a testifying witness as opposed to, for example, someone who just provides information and gets a reward. That's the first thing, testifying witness. The second thing is you have the reward that is contingent upon a conviction, as opposed to, for example, somebody giving information and then getting paid upon arrest. It is contingent upon conviction. And then you have if you have a prosecuting attorney who is engaging in a process that is facilitating the promise of future payment to a testifying witness, that is the third factor. Now, I think all of these individual factors...
The problem is that also includes restitution for a victim, doesn't it?
Well, it only... Well, I think restitution for a victim is sort of a separate situation. I think in this case...
It's a financial incentive for the victim to testify in a certain way because the amount of money that the victim will obtain is dependent upon the conviction of the individual.
Well, true.
And sometimes restitution is in the thousands of dollars, 100,000. I mean, these larceny cases are very big restitutions.
But the victim is a victim. Here we're talking about a third-party fact witness. And in this case, all of these factors, not just looking at each one of them individually, all of the factors are present, and that is what distinguishes this case from any, looking throughout time and identifying cases that mention the word reward. If a reward is for information, rewards not contingent upon conviction, rewards that occur with a process that doesn't involve the prosecuting authority.
So you're saying you wouldn't have an objection if this were a reward for information leading to?
That's correct, Your Honor. I don't think exactly. But here what we have is we have a testifying witness, a fact witness at a legal proceeding in a criminal trial. We have that witness who has a cash incentive to testify in a particular way, because if they testify in a particular way contingent upon conviction and imprisonment, they will get it. And you have the prosecutor who engages in the process to make this happen, which I think is very significant, especially when the prosecutor did it in this case, when the entire premise of the reward system didn't exist. This wasn't an unsolved homicide. But
has this issue come up in other jurisdictions, the question of payment for testimony by a civic association? Because I know you cite other cases, but those didn't seem to be criminal cases to me anyway.
Well, right. I mean, there are various cases. Most of the cases, and even in the many cases that were submitted late by the Commonwealth, those involve variations of this. They don't typically involve all three of these factors, and if they did involve all three of these factors, I think they're very, very rare.
Well, has any case excluded the evidence of a testifying witness because the witness received a cash reward?
Contingent
cash.
Your Honor, there's no case in Massachusetts where this
No, I
has
didn't
ever
say
come up.
we know there was
I
in Massachusetts.
but-
Other places.
Right.
Other
I mean,
jurisdictions.
I can't think of one off the top of my head. I can't even think of one that has this
Did you look
precise
for one?
situation.
Did you look for one?
We did research about rewards. Yeah, I mean, we have.
How about the whole key tam statute? I mean, the key tam statute under federal law, under the False Claims Act, permits somebody who brings to the attention of the federal authorities and may very well be a witness the possibility of getting millions of dollars, especially in the pharmaceutical area. That we've had a number of cases over the last decade in Massachusetts in which key tam plaintiffs have won millions.
Right. And I addressed that in my reply brief, and I think that it's very subject to abuse. It's in a civil context. It's not in a criminal context. We're not talking about taking someone's life away, essentially.
So you would add a fourth factor. You would add a fourth factor.
That it's
in a criminal.
Yeah,
Yes.
I think that's
Because
very
in a
significant.
That's where due process applies.
Absolutely. And I think if the court looks...
But in the key tam, obviously there'd be collateral consequence to the conviction, which will enable the key tam plaintiff to prevail. I mean, it's not as if there's not an incentive for the key tam plaintiff to get a conviction.
Right. And most of those statutes in England, they've been entirely repealed because they were so subject to abuse. In the United States, they've mostly been repealed because they've been subject to abuse. They've been a huge problem.
Well, the issues, there are lots and lots of payments to people, and in a variety of contexts, and then they may then testify in a criminal case. It seems to me that what is at least different here is you've got in the criminal case, you don't get paid unless you get a conviction.
That's right. You certainly don't.
I mean, there are lots of witnesses that get paid in lots of contexts.
That's right.
And they may or may not testify in a criminal case.
That's exactly right. And if they do testify and they had already been paid, that would certainly make it less of a violation. And I think then the court's got to look that 268.3, it's separate and apart, it provides a whole nother problem here. And I think that if you look at those three factors that I mentioned, if you stay away from those factors, certainly a testifying witness, you're not going to have an issue relative to the statute. And I just want to emphasize that we are asking the court to look at this in terms of the very process that was implemented to prosecute and convict Wayne Miranda.
Now, you say that this is not a question of competency, but it sounds like you're claiming that these witnesses are incompetent to testify because of their incentive to fabricate.
We're saying that first off, it is fundamentally offensive.
Right, I understand that, but
Okay,
but you're essentially saying that when a witness of this sort testifies, it's structural error requiring reversal, and therefore, for all practical purposes, the person should be deemed incompetent to testify.
You could use the word incompetent, but competency generally in our law goes to factors about mental capacity and ability to
but
observe
historic-
and so
but
forth.
But it can't be
historically-
biased because the bias has been brought out and put before the jury. And
But Your Honor, it's sort of like saying we're going to permit a process that is fundamentally unfair, but if there's the opportunity for cross-examination, we're going to let it go. And like I say in my reply brief, it's much like saying, well, we did put the defendant in a box, but when he was in the box, he didn't have his hands tied. Well, you know, I mean, we don't think that's sufficient. And what we're saying here is that this really goes to the fundamental aspects of the system. Is the government going to...
And somehow cash is different than other things of substantial value.
I think cash or equivalent is
So what is the difference? Just because that's sort of what we always been doing, deals have always been made, plea bargains, et cetera, so that's okay because it's sort of always been part of our mix?
Well, the plea bargain surely is not contingent on a conviction.
That's right.
The plea bargain is contingent on the witness being absolutely truthful. That is it seems to me, that's a very different bargain.
Right. And
in other words, the prosecutor, whether or not there's a conviction in a plea bargain, the prosecutor can say, but you didn't tell all of the truth. There might or might not be a conviction, but if the deal is you tell the truth, the whole truth, otherwise the plea is not in effect, that's different.
That's right, and that goes to that second factor I mentioned,
And
contingency.
it's no defense for the recipient of the plea bargain to say, but the guy was convicted or the woman was convicted. That's not a defense. It was, no, you were supposed to tell all of the truth, and you didn't do that. You said you couldn't remember when you'd previously told me you could, or whatever the heck it is.
Right, and I asked the court to look at, in my reply brief, the A.T. Caperton case. I mean, this is really very analogous to a judge being biased. We don't say, well, you know, the judge's decision can be held up in the light of day with respect to what happened in the case, and if the judge writes a decision, we can measure the decision against current law and see whether it seemed like it was out of bounds. No, we don't say that. We say judges can't have financial interests in case.
That's Caperton is, in a sense, this is worse than Caperton, because Caperton, there wasn't even a commitment to rule in a particular way.
That's right, and I think
at least as far as we know.
Yeah, and the way that the Supreme Court states it, and I'll quote it, under a realistic appraisal of psychological tendencies and human weaknesses, the question is whether what occurred in this case poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of due process is to be adequately implemented. The question is whether there's a probability of bias that is too high to be constitutionally tolerable.
Well, let me ask you this. Let's move it a little bit. There are plea bargains. There are various forms of cooperation agreements, testimonial plea agreements, one of which is that you essentially agree to testify consistently with your grand jury testimony. That would be over the line, would you say, or no? Because that sort of makes your plea or your bargain contingent on a certain form of testimony.
I've never seen an agreement quite like that saying that, but I think that poses some fairly significant problems, but it's certainly not contingent upon conviction.
Okay. The second question is really going to 268A Section 3, which is what you sort of highlight as one of the major principles in our law that bars this kind of conduct. With respect to that, though, and I guess my question earlier really went to that, the statute doesn't talk about cash. It talks about giving anything of value for or because of or in connection with testimony. Would you say that plea agreements in which one gets a reduction of charges or a reduced sentence would also violate that?
Well, Your Honor, I would refer the court to the Medina case and Judge Gertner's analysis. I mean, I don't have a reason to disagree with her analysis relative to those traditional aspects of our criminal justice system and plea bargains and so forth. But, you know, I certainly think that when you have a fact witness.
But the statute, the 268A Section 3, doesn't really focus on the contingency of a conviction. It's a lot broader than that.
It's for or because.
It is.
Yeah.
That's correct.
So the point that you're making is, I take it, that the crux of your case is that the incentive is to testify so forcefully for the Commonwealth that a conviction will result.
Right.
That it's goal-oriented.
Right. And we're saying to a fact witness that, hey, you know, we have certain benchmarks through this entire process, from grand jury to conviction. And if we meet these results, we're holding this out, you get paid cash. Wow. I mean, that's really far outside of anything that we've ever permitted in our criminal justice system. And I just want to emphasize with the court, I ask the court to recognize that we are asking the court not only to look at the due process statutory ethical guidelines here, but we are asking the court to look at its own supervisory powers in this case. It's hard to imagine that this can be permitted in our criminal justice system.
Mr. Shaw, let me ask you this, and I'll ask the same question of Ms. Eisenhower. This is in the Bristol County DA's office. Do we know whether this is taking place in any other district attorney's office?
Your Honor, I've not heard of anything like this in any other county.
It's the Chamber of Commerce, though. It isn't the district attorney's office.
Well, the district attorney,
Well,
participation in the Chamber of Commerce.
From what I read in the brief, it said the district attorney's office discouraged this practice.
No,
discouraged them from adopting it. No?
Your Honor, there's no dispute from the discovery that occurred that the district attorney's office was aware. And if you look at the testimony...
Oh, I'm not saying they weren't aware, but...
I thought they participated. I thought they sent
sent a letter.
They did. In other
They had
words...
to send a letter, yes, but there was something in the brief that indicated that the district... maybe we should wait and ask the district.
Well, what if they didn't participate? What if there was simply an offer by the Chamber of Commerce or some third party to testify, and if your testimony resulted in conviction, the DA discouraged it? Let's assume the DA discouraged it. Is your argument the same?
The argument becomes a little bit weaker at that point, a little bit weaker, because, I mean, it makes a significant difference when you have the essential link in determining who got paid was this, it came from the DA's office. And this has been going on according to the discovery that occurred since 2004. They were aware that this kind of system was in place. And, you know, does that give...
Why is the argument weaker?
Well, I just think that it's much more.
They
I think it's much more egregious when you have a prosecutor who is taking any action that facilitates cash
but
promises to his own witnesses.
So, are we punishing the prosecutor? What are we punishing here? Are we punishing government involvement in this kind of thing, or are we trying to get after inherently unreliable testimony?
We're trying to get after a process that is fundamentally unfair, that resulted in a fundamentally unfair conviction. And, you know, we don't have any particular interest in...
Is that process any less unfair if the DA discourages it, but the witness comes forward with those kinds of incentives?
No, but I think that when you have a prosecutor who is actually taking any action which helps facilitate cash contingent upon outcome to his own witnesses, you have a very severe problem.
Mr. Shaw, let me ask you this. If this was known to the district attorney in 2004, 2005, 2006, 2007, 2008, 2009, and 2010, there are a lot of criminal cases in Bristol County. Do we have anything in the record that tells us that the district attorney knew that certain witnesses were testifying on this cash reward system contingent on conviction, knew at the time that a trial was going on, but did not disclose that to defense attorney?
Your Honor, I have no evidence of that.
There's nothing in the record.
No, there isn't. No, there isn't. And I have no evidence of that. And
Mr. Shaw, let me put the shoe on the other foot. Let's say there's a defense fund and money is offered to a witness to testify that results such that you get your money, you get paid, contingent upon acquittal, should that witness be permitted to testify?
No.
So a defendant can be barred from presenting that kind of testimony.
I mean, I don't think you can have, I don't think you can have, I think that it would be unethical, for number one, for any attorney.
Apart from the ethics of it,
Engaging that.
should the witness be barred from testifying?
I think in a court, even in the Singleton case, Singleton 2, and the Medina case that I've cited, I mean, it is presumed in our system that we do not hold out deals like that to witnesses. And I've never seen that happen. I just can't imagine that we could permit this to infiltrate our system of justice, and it doesn't seem right to me. Of course, that's not our case here before you today, but you know, it seems, you know, that's, we just can't be prosecuting people and putting them in prison based upon this kind of cash incentive.
Okay, but is it different for a victim? You didn't answer the question. Would you say that this applies also when victims have financial incentives based on conviction, which they very often do?
Well, I just want to point out, Your Honor, and
It's a yes or no. I mean, are you including incentives to victims, whether it be restitution or the possibility of collateral estoppel and related civil actions?
well, Your Honor,
Would
I
that
think there's
disqualify them?
I think there's a fundamental difference when you're talking about a victim who is going to be restored to where they were before they were harmed.
But what about the victims, say, for instance, of the sexual clergy abuse? They bring civil actions for tons of money. Lots of other victims do as well. And their civil suit is greatly enhanced if they've got a criminal conviction. In fact, many of the civil suits are stayed pending the criminal trial for various reasons. And are we going to bar them from testifying because they're assisted in recovering $1 million if there's a criminal conviction?
Well, I think that if you look back through history, you know, there's always been an exception made when you have an offense and a victim, and the victim is the only person who can provide evidence that the offense occurred. And I think that when you're talking about some sort of restitution that's going to occur outside of the context of the present criminal proceeding, that's quite different. I mean, we're talking here not about a victim.
Well, it's not restitution when it just comes to damages and emotional injury damages, et cetera, et cetera, et cetera.
Well, it's a form of restitution. I mean, you know, if somebody's been harmed by being abused, then, you know, the compensation to which they're entitled is related directly to the harm that they've suffered. And again, probably occurring in a separate proceeding, not a fact witness, and not cash, coming contingent upon conviction.
Thank you, Mr. Shaw.
Thank you.
May it
Good
please the
morning. Good morning, Ms. Eisenhower.
Good morning. May it please the Court, Rachel Eisenhower for the Commonwealth. I did look at whether there are other programs like this in the Commonwealth. I'm informed by the Northwest District that there's an Arson Watch reward program.
I'm sorry. I just didn't hear what you said.
There's an Arson Watch reward program that's a standing program that provides funds for rewards in arson cases. I don't know.
In Springfield?
It's Northampton
Northampton.
was where it was from,
Yep.
and it's funded by the Mass Property Insurance Underwriting Association out of Boston.
And that's contingent on a conviction?
I don't know whether that is contingent on conviction.
And either side, if there's information that you'd like to provide afterwards, that will be fine.
Oh, okay,
I
that
have
would be
a
fine.
question
I just
for
don't want you to have to use up your time.
Sure,
you know.
there are other programs, but I will provide that by letter.
What do you say about the Mass Rule of Professional Conduct 3.4, whatever it is, I, that, no,
It's G.
it's G, that no attorney shall pay, offer to pay, or acquiesce in the payment of compensation to a witness contingent upon the content of his or her testimony or the outcome of the case. Why is not what happened here a violation, at least of that ethical provision?
There are several reasons I don't think that the wording of that can be read literally in this case. First of all, no one has interpreted Rule 3.4 to apply to witness relocation programs that are provided by statute. So if the Commonwealth can directly provide cash through that means, historically, yes,
It's contingent.
it is contingent.
What is contingent? The witness relocation program?
Oh, no, no.
The difference is contingency.
understand.
There are tons, we'll stipulate, there are tons and tons of inducement programs.
Yes.
There are civil actions that follow criminal cases where there was and wasn't a conviction.
Yes.
And the argument, if there is a conviction, is it strengthens the case. If there wasn't a conviction, the preponderance of the evidence is lower than beyond a reasonable doubt. There are witness relocation programs. There are just lots of...
I understand. If
So you have to focus on contingency.
Yes, on contingency. If Rule 3.4 were to be read literally, it would prevent plaintiff attorneys from calling their own clients to the stand because they would be receiving money that is contingent on the outcome of that case.
There are special provisions for contingency fee arrangements that are specifically permitted under the rules, with very clear, under Rule 1.5, with very clear limitations.
But those contingency fees go to the lawyer accepting a contingency payment, not his client accepting a contingency payment.
Right.
And Rule 3.4 determines whether the lawyer can call a witness who's receiving a contingency fee. And since it's the client and the plaintiff client whose reward is contingent, then there's no exception for that.
Well, I mean, certainly, is it your position that it would be ethically appropriate for a prosecutor to say, we will pay you $1,000 if we win as a bonus for your testimony?
If it were fully, I think that the two touchstones are disclosure and cross-examination.
No. The question is not whether or not it would be, the person would be competent to testify, and the question is whether or not it would be a breach of our ethical rules, whether that would be appropriate behavior ethically by a prosecutor.
It's probably fact-specific.
What do you mean?
I mean that...
It's not that you've just got all of the facts. If there's a conviction, I'm going to pay you $1,000.
I don't know. I don't wish to opine as to one of my colleagues' ethics.
No. Nobody's suggesting that you're opining as to one of your colleagues' ethics.
Fair enough, Your Honor.
That's why I gave a separate hypothetical, because that's not the case here. But
Okay.
it's the principle of a bonus in return for a conviction to witness.
Certainly there does come a level at which a proposal would violate the ethical canon. I agree. The distinction I'm attempting to draw is that where there's a historical basis for these reward programs, both in Massachusetts and throughout the 50 states, that Rule 3.4 can't have been intended to forbid what had already been going on without expressly saying, and these reward programs, we mean that too.
Well, have you found any
they're not
case?
contingent.
Have you found any case in any other jurisdiction where there is a program with a contingent program, contingent on the outcome of the case that has not excluded the testimony?
I believe many of the cases I cited in the 16L letter are contingent. In fact, the Mississippi statutes expressly say that even when the reward is for information, the payment shall not be received until there is a conviction, which to me is a contingency.
No.
But the problem is the distinction my brother's attempting to draw between a reward for information and a reward for testimony collapses, because if the information is truly unique, the Commonwealth will want to call the witness to testify.
Yeah, but then the Commonwealth, and frequently, I mean, there are very ethical assistant district attorneys who stand up here, month after month and saying absolutely forthrightly, the deal is that you testify to the facts, all of the facts, and nothing other than the facts. And the Commonwealth has no interest, it would say, fairly, on whether or not that results in a conviction. All the Commonwealth wants is that the fact finder, the jury usually in a criminal case, be given truthful testimony. I mean, it seems to me that it's different than when it's contingent, in the words of the rule, on the outcome, or it's contingent on particular content. I've never heard of any plea agreement where it is contingent on the witness saying a particular thing. It's always contingent on the witness being truthful.
I understand, Your Honor. But contingency is a common way historically to set up these reward programs.
But it depends what it's contingent on. Contingent on showing up in court is different than contingency for the outcome of the case, the specific outcome or specific testimony.
Well, one of the issues, though, is I do think that what are you going to do if the question is the reward program is a reward for information, not for testimony, nothing to do with testimony, but it will only be paid upon conviction.
I don't have that case.
That's true, but if we rule, if you rule, I'm not going to rule anything.
I don't follow Mississippi in determining what's appropriate in Massachusetts, and I haven't looked at the Mississippi rule.
I understand that, Your Honor, and nor do they have the Declaration of Rights, so it's, of course, a completely different situation.
No, they have due process in Mississippi, and I haven't looked at all the intricacies of their rights, of their rules.
That's true. I would note that we do have Commonwealth versus Ciampa, which does in a footnote say that contingency plea agreements are inappropriate, and I have 5 reasons that I think that the plea agreement situation is distinguishable from the cash rewards. First, because...
But does that help you? If the plea agreement is different from the cash rewards, how does that help you?
Because I think that the rule in Ciampa that plea agreements shouldn't be contingent, shouldn't be extended to cash rewards. For one, because of the value of liberty.
It's not cash rewards. It's contingent cash rewards. You have to keep putting the word contingent in.
I understand, Your Honor. Contingent cash rewards.
Yeah.
What was the district attorney's participation in the program? I do remember reading somewhere in a brief that they discouraged this program.
The testimony of James Mathis, which never states that the reward is for testimony. It states it is for cooperation, and in fact, there is at least one case in which people received rewards in which they did not testify. It was a guilty plea, and they received the rewards through the program. However, since they stood ready to testify, that's hardly something to rely on. Mr. Mathis testified. The reward was started in 2004. Paul Walsh was the district attorney at the time, and he discouraged the program, as James Mathis testified. Originally, the program required some sort of verification so that they could determine before spending the money whether the money that they were giving out into the community had actually helped its purpose. And so they decided the best way to do that was to seek a letter. Now, in this case, testimony reflects that it was not Mr. Veery who initiated the discussions about the reward program. It was the witness himself, who was an active community member, knew about the reward program, and asked if he could have a letter to reflect his participation in the case. Mr. Veery wrote the letter for him and wrote the letter for his companion as well.
Was the letter written before or after?
There were letters written between the indictment and the trial, and then there were additional letters written after the trial, because the setup of the program is $3,000 following indictment and an additional $2,000.
And how did this come to the knowledge of the defense attorney?
It was disclosed.
Do we know of the other cases where the prosecutor knew that there was witnesses who were testifying in exchange for contingent cash rewards that were not disclosed?
I looked at the cases. I got a list from the New Bedford Chamber of Commerce of the checks that they had cut to witnesses, and I've been working backwards to figure out which cases it was. One ended in a plea. One was recently affirmed by this court on 33E, and I believe that there's no mention of it in the testimony, which suggests to me that there may not have been disclosure, but the dates the check were cut follow the trial. So it's entirely possible that the situation simply hadn't arisen at the time of trial. There's a second-degree murder case in which there was cross-examination about it that's currently pending before the appeals court. And there's this case, and then there's money that's been paid for an indictment that hasn't gone to trial yet. And that's the sum total of all of the cases that New Bedford Chamber of Commerce has paid money in.
You've done a good job investigating.
Well, it's a little outside the record, I'm afraid, but I anticipated that might be a question.
You argue that if it is a violation of the ethical rules, it still doesn't mean it's not admissible evidence.
That's true. I'm primarily here to deal with the conviction, and
You also argue that if it violates 268A Section 3, also that doesn't mean it's inadmissible.
That's true under the federal analogy.
Right. But would you concede that it appears to violate 268A Section 3?
It does appear to violate the text of it.
I think this is where you get into, in this case, you don't want to opine on somebody else in your office, correct? I mean, I'm not suggesting, Justice Cordy, that she can't answer the question, but it's a...
No, all right. Let's remove it from the context of this case. Mm-hmm. I don't think it could be clearer. Anyone who directly or indirectly gives, offers, or promises anything of substantial to a person for or because of their testimony in a case violates Section 3. I don't understand how to read it any differently.
It's true, but I believe, as Justice Gantz noted, that doesn't apply to things like plea agreements, things like...
Well, I'm asking that. I don't know. I never really focused on 268A3 in this context.
Some of the federal cases, and this is one of the places where it's interesting, the state actor distinction. If the state was acting as the source of the money, the federal corollary to the statute, 201C2, I believe, there's a lot of case law discussing how it doesn't apply to the government because it wasn't intended to apply to the government. It doesn't affect their normal prosecutorial authority. So if this were a reward program run by the government, for instance, the Worcester DA had the reward for Molly Bish, which he said in an affidavit he intended to be contingent on conviction, whether it's an affidavit. I mean, who knows how the program was really set up. But the 268 section 3, presumably under the same analogy, wasn't intended to apply to prosecutorial functions like that.
And I take it that would include witness protection programs.
That would include witness protection. That would include plea agreements. And I believe that cash rewards are a traditional prosecutorial function. It's mentioned in a Hawaii case in the 16L letter that they are. I mean, I realize that doesn't govern this court. But
is the statute, the part of 268A, Section 3 that we're talking about, subsection C?
Yes, subsection C.
Whoever knowingly, directly, or indirectly gives, offers, or promises anything to any person for or because of testimony under oath, but the assistant district attorney didn't give, offer, or promise anything.
That's true. So the individual who gave, offered, or promised something would actually be the Chamber of Commerce, not the DA, which is why I said it's interesting whether there's state action in the reward. And private rewards are just as traditional as the state rewards. So I think that perhaps when a private reward is offered in the conviction context, that we should view it as they're sort of adopting the role of the state in that sort of public spirit, the same way that...
Who called the witness?
Pardon me?
Who called the witness?
The state called the witness in this case, yes.
But that wasn't giving, offering, or promising anything to any person. The Chamber of Commerce may have violated the statute.
That's true. But the one problem with requiring the prosecution to distance themselves from these private rewards is that the further the prosecution is distanced from the private rewards, the more dangerous it is for the defendant, because while the prosecution has a Brady duty, the Chamber of Commerce does not. So the further we get removed, whether it's from ethical duties or any other reason, if those private rewards are still out there, it's actually going to harm the defense. If there are no further,
Thank you, Ms. Eisenhower.
thank you.